Hi comrades, yours Kayveeyes. We are seeing that the Notional Increment Case for the 30th June and 31st December retirees being tossed from pillar to post, and the government has decided to consult once again with the Supreme Court about amending the FR and SR and also the implication of the implementation of the said judgment. It is very pertinent to say that the Supreme Court had sent strong messages against the rising trend for filing frivolous special leave petitions by the Government of India, by the various departments. The same should be applied in the case of notional increment also. The Supreme Court has imposed a cost of rupees 5 lakhs on the centre for challenging the Meghalaya High Court order, holding it was sheer abuse of process of law for filing frivolous petition 561479A in the bench of Justice Vikram, Nath and Sathish. It is observed that the petition is sheer abuse of process of law. The Supreme Court disposed the case after taking note of the central government claim that a similar plea has been rejected earlier. The court imposed a fine of rupees 5 lakhs to be paid by the petitioners within 8 weeks. This is very pertinent, but in the case of 30th June retirees, almost the Supreme Court has given various judgments that it is applicable to all the similarly situated employees and pensioners. The judgment is firm, and even after that they want to seek clarification that it is a frivolous nature only, it is a frivolous petition, it can be brought under this category. In another case, Ranbir Singh versus State of Uttar Pradesh, against the rejection of his promotion, the SLP was filed. The Judges Gavai, Bindal and Mehta refused to withdraw the petition but also imposed 1 lakh fine. Even though the government wants to withdraw the SLP, but they have not allowed at the same time, they have given a penal recovery to the extent of 1 lakh as a fine. The court raised concerns about a growing trend of filing petitions against ordinary orders and matters. Seriously, this is applicable in the case of notional increment to 30th June and 31st December retirees, as well as the employees who are in service. For one RTI reply, Right to Information Act reply, the DOPT, by its letter dated 15/4/2024, informed that the orders of the Supreme Court necessitate examination of a few aspects emanating there and is likely to take some more time to take further action. So the government is not in a mood to settle the issue as earliest as possible. It wants to protract the issue on one pretext or the other. The Additional Solicitor General, Supreme Court of India, via file number 101028, dated 4/1/2024, have already given the opinion to implement the court decision to all the similarly situated employees or pensioners. As such, approaching Supreme Court once again for seeking clarification other things, this is nothing but to protract the case and to either deny or delay the case for a long period, nothing otherwise. The Ministry of Home Affairs, by its order dated 1/4/2024, has allowed 1 increment to all those retired for calculation of pensionary benefits. The Ministry of Home Affairs has already implemented the orders, and this is a good sign. This is sufficient, and the government decision to seek clarification further in the Supreme Court is nothing but frivolous nature, and it should also be dealt in the same manner as we discussed in the case of Meghalaya High Court order, and also the another case we discussed about the Uttar Pradesh. The pensioners associations as well as the staff associations and unions should take note of this and to implead or file a case and do something. That is the need of the hour. The pensioners are most agitated. They are very much agitated due to non-settlement of the issue, even after 1 year of the final judgment made in the Supreme Court. They are very much fed up. They are seeking some remedies. The delay is causing a concern. Some of the retired persons, they may not get the arrears while they are in during their lifetime. The problem is also there. So the Pensioners Association as well as union should file a case and see the remedy immediately, or otherwise it will increase the mental agony to the pensioners as well as the government employees. With this, I am concluding. Thank you very much, comrade. Meet again.